The lecture that opens our series will be given by Professor Emilia Justyna Powell. She is a professor of political science and concurrent professor of law at the University of Notre Dame. She has written extensively on international law, international courts, international dispute resolution, the Islamic legal tradition, and Islamic constitutionalism. She published articles in journals and books with Oxford University Press and Cambridge University Press. Professor Powell studied law at the University of Cambridge. She holds her PhD from Florida State University and has been a fellow at the Oxford Center for Islamic Studies at the Durham University and at the University of Copenhagen Law School Center for International Courts. She will talk today on Islamic law and international law, peaceful resolution of disputes. Thank you once again for accepting to be part of our project. Now the floor is yours.
Thank you very much for inviting me to this wonderful forum. I really appreciate to share my thoughts with you. I indeed think that your institute has very important role to play in what are so many misunderstandings in the world right now. So definitely I'm going to present on my book that came out 3 years ago now, Islamic Law and International Law, Peaceful Resolution of Disputes. I'm going to start to relate this project to your noble goals in your institution about focusing on the legal traditions and legal systems in the Levant. And of course, my research looks not only at Levant, but also at other parts of the Muslim world. So the reason that I engaged in the research on the Islamic legal tradition in the context of international law is twofold. Number one, scholars, in my opinion, especially those that write in the English language, have not given enough of attention to the Islamic legal tradition or to Islam as law, as legal tradition. Why is it? I think that a lot of people, be it scholars that are not familiar with Islam and policymakers as well, when they hear the word Islam, they think mainly about the religion, perhaps culture, but the legal aspect of Islam is often misunderstood, if not ignored. There is a huge misunderstanding in that context because of crucial importance is the reality that Islam for centuries has constituted a legal tradition, a complete legal tradition with a deep history, deep systematic analysis, and really unprecedented jurisprudence that goes beyond religious perceptions and focuses on finding legal solutions to legal problems. Moreover, scholars and policymakers alike, and not to, of course, forget an average person here in the United States or in Europe, in Africa, I would make it a worldwide expectation or realization of the reality that people see Islam or the Islamic legal tradition in my context as a one category without any divergence, so a monolith. People think that Islamic law in the Kingdom of Saudi Arabia is identical to the Sultanate of Oman, is identical to Algeria, Malaysia, Indonesia, and so forth. And of course, they're wrong. I would say that most scholars, policymakers, and average people simplify the Islamic legal tradition and focus only on the textual sources of the Quran and Sunnah, particular interpretations, and at the cost of downplaying or not realizing the immense diversity of the Islamic legal tradition. So number one, most people are unfamiliar with the fact that Islam has been, in fact, a legal tradition. Number two, they misunderstand the fact that Islam is not a monolith, but it's incredibly diverse. And number three, and this relates more to my field, throughout my writings on international law, it has become apparent to me that most scholars believe that the Islamic legal tradition, historically and in the context of modern realities, is fundamentally divergent from international law. There's much writings in the English language on how there is not much dialogue between those two areas of law, and that there's nothing in common between them. And of course, that's false. Not only does that stance hurt any prospects for global peace in the context of cooperation with Muslim majority countries, but it fundamentally misunderstands the Islam's contributions to contemporary international law. So these are the main reasons why I wrote the book. I think that it relates very well to the Institute's goals and hopes in focusing on the importance of legal traditions. I want to briefly speak about why I believe legal systems or legal traditions are so important. Of course, in the context of Islam, I like to use the concept of Islamic legal tradition, not legal system. Why is it? To me, as with other legal traditions, major legal traditions, so civil legal tradition, common legal tradition, there is much legal ordering going on outside of written codes or traditional normative, systematically organized legal system. There are concepts such as customs, unwritten norms, and expectations that really determine how a legal tradition operates. And this is especially crucial in the context of Islam. In my book, I introduce a category of Islamic law states. This is a category that focuses on legal tradition or legal system. So in order to be categorized as an Islamic law state, Islamic law, a substantial part of a domestic legal system needs to be charged with obligatory implementation of Islamic law, and Muslims must constitute at least 50% of the population. That's the category that I have come up with in my scholarship. Why is that so important? Why do I believe the focus on law is so important? Really, legal tradition of a country, more often than not, is a credible signal of the country's identity. Because it's one thing, let's say, for a population to be Muslim or Christian, any religion really, but it's other to incorporate religious precepts in domestic legal system. I feel as though, more often than not, if we find religious language in law, a state, so a government, policymakers are trying to signal something, signal the state's goals, identities, not only vis-a-vis international audiences, so other states, but also their domestic audiences, so their own citizens. And such commitments to Islamic law, in the case of my research, is costly because there are in turn expectations on the part of the citizenry and the global order. with regards to the behavior of a government. I focus on 29 Islamic law states in modern times that cover all parts of the world. So I go beyond Levant and the Gulf, but focus on countries in Africa, Asia, Oceania, and Africa. And again, one of the greatest understandings here in the United States among average people is that Islamic law states, or if you wish, the term Muslim majority countries, are pretty much limited to the Levant and the Gulf. And that's false. Because Islamic legal tradition has, as you know, informed historically and in contemporary times legal regulations of countries really located all over the globe. One other important aspect that I would like to delve in before talking about Islam in the context of international law is that the Islamic legal tradition is not only diverse in a cross-sectional sense. In other words, different countries across the globe have diverse understandings of Islam. But as you know, the diversity is also temporal. Therefore, domestic legal tradition of Iran or Saudi Arabia or Algeria, Morocco, 20 years ago, 30 years ago, is not what we have right now. There's movements in how many religiously relating language is included in the legal system. One other thing I would like to emphasize is that, to me, a legal tradition, how do we look at a legal tradition of a country? We have to go beyond a constitution, first of all. So many scholars try to measure, let's say, the presence of religious language in particular countries by merely looking at a constitution. And as we know, constitutions are very important. However, they're not a complete normative structure of any country. We have sub-constitutional legal system, so legislations, codes, and statutes, which really determine everyday lives of citizens in the context of every society. Therefore, I take this holistic approach to the Islamic legal tradition and measure the nexus or the relation between Islam, Islamic law, and secular law in 29 Islamic law states across the globe from Second World War till modern times. And I measure that nexus in the context of constitutions and sub-constitutional legal systems. That means that for about 8 years, I have been working with multiplicity of students to gather data for this project and record things like, how many times is God mentioned in a constitution? Can women be judges? How many times is Sharia mentioned in the constitution? Do policymakers have to take holy oaths? Is there customary law mentioned in the constitution? Is there peaceful resolution of disputes mentioned in the constitution? And as you mentioned in your presentation that began our conversation today, peaceful resolution of disputes is of utmost importance in the world. I mean, we have conflicts going on all around the globe, and an average citizen here in the United States, and I know that the same is true for Europe, Africa, Latin America, Asia, Oceania. We tend to watch news for a while, but then we get tired with it and we just stop dealing with it. Yet those conflicts cost millions of lives, tragedy, human, material, and spiritual loss. This is why understanding the nexus between Islamic law and international law is incredibly crucial. So I want to briefly perhaps address now what is my approach in that book? I feel, and I already mentioned this before, scholars really have focused on the differences between Islam and international law, and similarities have been largely ignored. The effect here in the United States and in Europe as well, I would say, is that we have abundance of scholarship that focuses on the differences, and it doesn't do anybody any good, other than we need to recognize those differences. It's never good to gloss over those differences. I mean, we have international criminal law, human rights law, in which convergence of Islam and classical international law is quite challenging. So we need to recognize that. But it's also equally crucial to focus on similarities. So as far as differences, of course, number one difference is the relations between law and religion. In the Islamic legal tradition, we have this close connection between law and religion, and it's hard to separate those two abodes of norms. International law in modern times is supposed to be secular. Of course, we all know that, yes, the norms are secular right now, but they stem from philosophy, influence of the Christian legal thought. And so then when Islamic law states interact with classical international law, there is this disconnect sometimes. How do we understand notions of justice and other substantive norms? Of course, in the Islamic legal tradition, we have very unique sources of law, such as Quran, the Sunnah of the Prophet, analogical reasoning, and so forth. And most of those sources of juridical techniques are deeply religious, versus in international law, sources are, again, secular. And we have treaties, general principles of law, custom, judicial decisions, and writings of the most qualified publicists. So there is some disconnect. But again, I would like to focus on similarity. Oh, well, another difference perhaps I should highlight in the legal practice is that the position of women in the courtroom has been a point of contention among Islamic scholars. I would say that while historically, for the most part, women have been, I would say, excluded, if not fully admitted into the courtroom proceedings in Islam. Modern times is, of course, much more inclusive, but traditional Islamic law, according to most interpretations, reserves the role of a qadi, so a judge in a religious court, to a male. There were some exceptions, of course. In international law, we don't have any rules regarding gender. However, the reality in the forums, such as International Court of Justice, has been, up to most recently, that women were just not there. We see much difference since about 20, 15 years, but despite the fact that there are no rules against regulating gender in the courtroom, the reality has been that I would say men trained in the European legal system, so common law or civil law, have been sitting on international courts. So back to similarities. I'd like to highlight that in Islamic law, we have huge influence of scholars. Islamic jurisprudence, fiqh, has played an enormous role in shaping the Islamic legal tradition. And international law has a huge and very deeply rooted history of customary norms. So this is an important similarity that deals with the sources of law, acceptable sources of law, that's important to highlight Custom is another one. The Islamic legal tradition in various places around the world has a deep connection to local customs, where if customs are not contrary to Sharia, in different localities, custom becomes part of Sharia. And of course, we know that custom is also a primary source of international law. Again, important kind of procedural similarity. I would argue that classical Islamic law and international law have deep connection and deep de jure acceptance of the principle of rule of law. Both of them in written, in aspirational terms, I would say, are deeply devoted to rule of law. And of course, reality is different. And that's something that we need to strive towards bettering. But in this kind of background, I think the background that I explained here is really necessary to understand how complicated the relationship between Islamic legal tradition and international law is, because there is not one Islamic law or Islamic legal tradition. It lives differently in modern realities of societies. And the differences are that some countries, some Islamic law states include a lot of secular law in their legal systems, whether it be constitutions or sub-constitutional law. And some Islamic law states really focus on precepts of Islam, however interpreted, and include those in their legal systems. That's going to shape how they interact with international law. Because we have this amazing variance. So for instance, I would anticipate, and in fact, we all know it's true, that Iran several decades ago would interact differently with international law than now. The same is true for Kingdom of Saudi Arabia, and we can go down the list. So there is this complication. Really, I would say one of the major findings of my book is that number one, there is this huge diversity in Islamic law states, and this diversity is crucial in understanding their stances towards international law. Statements such as all Islamic law states hate international law, or they will dislike International Court of Justice or International Criminal Court, are just false. Because they are generalizing and don't reflect the immense diversity in Islamic law. Why is it? Because the nexus between secular law and Islamic law in the context of each of those states shapes how they see international law. And of course, we have to also remember about Islamic schools of jurisprudence that shape those countries' views of international law. Now, I want to finish my talk with maybe briefly mentioning dispute resolution, because the book focuses on a variety of things, but I would say the major contribution is contrasting logic of dispute resolution in Islam and international law, and laying out a path forward to cooperate with Islamic law states in the framework of international law. You know, international law via the UN Charter offers us a multiplicity of methods to settle disputes. States that are involved in a disagreement, after they decide that they don't want to engage in military confrontation, they can either negotiate, they can mediate, conciliate, or they can focus on binding methods such as arbitration and adjudication. These are methods that are binding according to international law, very formal methods. Mediation is very much, and conciliation are based on dialogue between the disputants, involvement of disputants in the process of finding legal solutions. In Islam, traditional dispute resolution is based on sulh, so non-confrontational approach, whereby the parties find an acceptable mediator, an insider, who kind of draws them in the resolution process. An outcome of this process is hopefully full reconciliation. And the book tells us that there is much convergence between mediation and conciliation as offered by international law and the Islamic logic of dispute resolution. So again, an important similarity. I think I would like to end here. There's no way I'm going to cover my entire book because there's so much details about international law and Islamic law. I'm very grateful for the fact that you've listened to me so patiently, and I'm happy to answer any questions you may have.
So, thank you very much for this rich and very interesting perspective, for this foray into the Islamic law and international law based more on connections and similarities. Now we have some time for questions, remarks. Any question is welcome. Please, colleagues, if you have something to ask. Then let's start by myself and ask the following question. I had a look on your book, which looks very impressive. And my question will be, how was the practice in the history of the legal Muslim schools, madhab or madhahib? I know that one important school of law was the Hanafi school, and its judges, its qadi, applied in their legal cases the Hanafi jurisprudence. So have there been any cases when they applied or made recourse to the jurisprudence of other schools of Muslim legal thought, for example, Maliki, Shafi'i? And if there are any differences between these forms of jurisprudence in civil law cases like divorce, inheritance, and so on?
That's a really great question. So I teach Islamic law and constitutions here at the University of Notre Dame in the United States. And when I introduce myself to my students the first class, I said, I can't teach you Islamic law in one semester because there's this huge diversity. As you say, the schools of jurisprudence, they each have a thought about pretty much every single thing that is of substance to an average Muslim and non-Muslim. So, of course, there's a huge divergence when it comes to family law, criminal law, property law, drafting wills, inheritance, pretty much across the spectrum of the legal tradition. Each school of jurisprudence has something different to say. They agree on many things, fundamental things, but there is such disagreement that it gives my law students headaches when we study this. Now, I would say that that's the beauty of Islamic legal tradition, because it gives a variety of views to interact with Islamic law. The problem that it generates is that we really don't know what Islamic law is, because there are so many divergent views, not only in the context of civil law, but also in the context of international law. There is also divergence within schools. So just like you mentioned, Hanafi and Maliki schools, it's not that they have one view. Everybody in the Hanafi school or Maliki school, they're going to have the same view. No. Different scholars within each school over time and also cross-sectionally might represent a different view. So things get more complicated. Do they consult with one another? That's a very good question. Yes, historically, scholars consulted with each other. Of course, sometimes they rejected the other's views. Sometimes they accepted it. The interesting thing that I find in my book is that countries that represent the different school of jurisprudence, such as Hanafi, Hanbali, Maliki, and so forth, Ibadi, this doesn't matter in how they see international law in modern times. I would say that the schools nowadays have lost their impact on countries' foreign behavior, foreign relations behavior. What I find is that location of countries matters. So Islamic law states in Africa will have different preferences from Islamic law states in Levant or the Gulf, but not Islamic schools of jurisprudence. Thank you for your wonderful question.
And thank you very much for your answer. Any other questions?
I have one question. I want you to ask is if there is any difference, a sensible difference in international dealings between for an Islamic state when it deals with another Islamic state or with a Christian state or a Buddhist state. How is this seen? Because from the point of your religion, as far as I know, I'm not a specialist, there should be a difference.
Mm-hmm.
Yeah,
that's an excellent question. You know, I think that would be one of the most frequent question I receive ever since the book came out. So you did very well. Yes. Number one question that I ask, am I a Muslim? Which is completely outside of the point and really weird. This is a question I was asked in really famous universities. I'm not gonna even name them because it's embarrassing. You know, actually, I was born in Poland, so I always love to speak in European countries. And I guess the thing is, people, number one, most scholars think that because I was born in Poland, I should study Polish law. I spent 5 years in Polish law school, and I was fine, but I decided I'm bored with it, you know. So, but yeah, the sensible question, what is the relationship between Islamic and non-Islamic countries? For the book, I did a series of statistical analyses analyzing this relationship. And I would say that the norms of Islam, as far as it comes to incorporating the Islamic logic of dispute resolution, so this kind of appreciation of mediation and not really engaging with courts, is stronger between two Islamic law states. So I guess what we see even in reality, when there is a dispute in the Levant or in the Gulf, most of the time, those countries will ask other Islamic law countries to help them. So they kind of communicate on the same waves. When they are faced with a non-Islamic law state, the relation is different because, you know, most of the time, Western policymakers, they don't have a clue about Islamic law. And if they do, it's a very negative view. And so then Islamic norms of dispute resolution are not something that bring those two sides together. There's usually dialogue and hope for peaceful resolution on both sides, but it's more often done in the context of Western legal traditions. So Islamic law states are, in those cases, expected to play like a Western country. This is my experience. Yeah, great question. Thank you.
So, any other question? Please, Anna Maria.
wonderful presentation. You spoke us also about the situation of female in the practice of law system. You said that they are not able to work as
Okay.
Okay.
Oh, yes,
Okay.
yes, okay.
Then we solved the technical problem. We are
That
back.
was great. Congratulations. Okay.
Thank you. Thank
So,
you.
so the question was about women, yes?
Yes.
if there is a chance for them in the future to become a Qadi or lawyers or in the apparatus, maybe?
Yes, that's a great question. You know, yes, really, I would say majority of Islamic law states now admit women to serve in the judiciary, but not necessarily in the religious courts, the Qadi courts, but in secular courts. So for instance, United Arab Emirates, I would say, is a great example here. Women are very much present in the structures of secular courts there. As far as, and you know, this is changing daily. I mean, not daily, but yearly. In my book, I traced whether women can be judges and the percentages there since Second World War till nowadays. And it's an astounding trend up. So more and more. But, you know, even if a legal system allows women to serve as judges, in some of those societies, you have societal norms that kind of prevent them. For instance, what if a male has to drive her to work? Or what if women have to be present with males in situations involving authoritative decision-making? It's just so, even though law accepts this, the reality doesn't always follow. I know that there are women Qadi in Palestine. There is actually really good film about the first woman Qadi in Palestine and the societal pressures that she faces. So the trend is upward, I think. And of course, we have situations such as in Afghanistan, where the trend was very much positive for many years. And now it's, of course, absolutely going in the opposite direction. So for the most part, there is trend upward with exceptions, I would say. Great question. Thank you.
If you want to ask other questions, please use the opportunity now. Remarks. We move on to the closing part of our conference. I would take the opportunity to announce that the next conference in the series will take place next Tuesday, June 6th at 6:30 p.m. with a guest and a specialist in Jewish law, Michael Broid from Emory University, Atlanta. He will talk on the codification of Jewish law in the 14th to 16th centuries in the Levant and East Europe. We would be happy if you could participate next week too, because as you can see, our conference connects spaces and addresses comparative thoughts and competing social and religious aspects of civilization. Now, I wish to thank once again to our lecture from today, to Professor Emilia Justyna Powell, for this privilege to introduce us into the practice of Muslim law and international law based on these similarities. We're looking forward to further opportunities to work together in the future. Thank you very much, and we wish you all the best.
Thank you very much. And it's been my privilege to speaking with you. Thank you for your wonderful questions. And I hope that you are enjoying, well, we have summer, no, not yet, late spring. Yes, thank you so much. Thank you.
And we promise that we will read your book.
Thank you. I would like to hear your opinions about it. Please, everybody feel free to email me. I always love to hear feedback about my work. Thank you very much, everyone.
Thank you.
Bye.
Bye. Bye.